Hello, I'm Jennifer Blue Rosman, Chief Human Resources Officer of Chrysalis Health. I'm here today with Eduarda Lacasa, our Chief Operating Officer and in-house legal counsel.
If you're new to Chrysalis, I'd like to welcome you to our company. And if you've been with us for some time, I'd like to thank you.
Talk to you today about HIPAA violations, confidentiality, and personal health information of our clients and families. As you know, in our industry, this is crucial for us to protect and maintain for the well-being of all of our clients as we're providing service provision.
One of my main duties here at Chrysalis is to oversee risk management. And in that effort, we have a corporate compliance program which you must be aware of. There are several measures that we encourage you to take to support your service provision should it ever come into question. These include sign-in logs at any school or facility that you attend that has such a sign-in log at the reception. Even if they allow you to come in without signing it, you should insist to sign it yourself. We also have our own form for sign-in for a client or guardian at the time of service delivery. We highly encourage you to use them. Chrysalis Health is committed to preventing fraud and abuse in regards to the healthcare programs that we deliver. And to that end, we have a comprehensive corporate compliance program which includes training our employees in regards to appropriate practices related to our documentation and billing. It also covers identifying fraudulent activity and how to correct such activity. We are governed by federal and state law with regards to false claims. You should be aware of federal and Florida governing laws with regards to the filing of false claims or fraudulent claims. Any person who knowingly presents a false or fraudulent claim or knowingly uses or causes to be made a false record in support of that claim or conspires to do any of these things is subject to the federal and Florida false claims penalty. These penalties are severe and include fines of between $5,000 and $10,000 plus 3 times the amount of any damages to the government. These penalties for violations of the federal and Florida False Claim Act include loss or suspension of your license. This loss or suspension is reported to existing or future employers. And of course, the most severe penalty is incarceration. Knowing or knowingly includes actual knowledge of any information that is false or fraudulent in support of that claim, or deliberate ignorance or reckless disregard for the truth of the claims that are being made. Chrysalis Health is a mandated reporter. Your supervisors and officers of the company, myself included, are mandated to report any knowledge or reasonable suspicion of a false claim being made. In Florida, the Medicaid Fraud Control Unit oversees and investigates potential fraud. There's a hotline for reporting. If you, as an employee of Chrysalis, become aware of any fraud committed by someone in this company or in any other company, we are mandated to report this. Florida also has additional Medicaid provider fraud statutes which include anti-kickbacks. If one is referring a client for a service that's paid for by Medicaid and receives anything of value, not just monetary, for making that referral, you are subject to the anti-kickback statute and can receive significant penalties for such violation. This is a third-degree felony. Anyone who has knowledge and reports such knowledge that results in an action against you is incentivized with a percentage of the recovery. These are called key TAM cases. This means that a client's guardian, or anyone else working in the field that becomes aware of any information which would lead to a false claim prosecution will receive a percentage of any recovery. Chrysalis Health supervisors conduct regular quality assurance and satisfaction surveys by contacting the clients or their guardians to inquire as to the services being delivered. These sometimes result in identifying discrepancies with regards to the service delivery. This will prompt us to make further inquiries by contacting an entire caseload and verifying the service delivery on the dates and times that they're being reported. In the event that we uncover such discrepancies, we'll ask you to come in, we will interview you. If we're unable to verify at that time the claims that are being made, we are mandated to report this to the Medicaid Fraud Investigation Unit. From that point on, they will undertake the continued investigation of the matter. In the course of the investigation by the Medicaid Fraud Investigation Unit, Chrysalis Health is compelled to suspend you without pay during that period of time. In the event that there's a finding of false claim, you will be terminated from employment.
So we're here today to speak with Eddie and ask him a couple of questions related to HIPAA.
Well, the most important thing that you must know about HIPAA, which is also known as the privacy rule, is what disclosures you can make that are permitted. Disclosures are permitted without consent of the patient. For the delivery of service or treatment, for billing purposes, or in the event of a potential for harm that is imminent to the client, you may disclose protected health information. Otherwise, we're going to need a signed consent for the disclosure of any protected health information. We have a variety of agreements called business associate agreements with other providers that we work with in the treatment of that client. Those other providers we are permitted to give disclosure of protected health information to. Law enforcement is also a permitted disclosure. In the event that you understand or you believe that a client is in danger of imminent harm or has been harmed in the case of sexual abuse on a child or a vulnerable adult, or if a law enforcement officer requests the information from you, you are permitted to make such a disclosure of protected health information. If ever in doubt, speak to your supervisor or contact me directly and I'll help to guide you.
In regards to consent forms, when we have an employee that's going out and working with a family, and let's say they're in the home, what's the protocol in terms of having consents for everyone that you speak to within that family unit for that client?
Well, one of the most important things about consents is to make sure that the right person is giving it. In many instances, someone may think that they have the legal capacity to consent just because the minor client happens to be living with them or staying with them at the time. Unless it's a parent whose rights are intact, or there's a court order which otherwise allows someone who's not a parent to sign a consent, you must make sure. You can also check with me or check with your supervisor to make sure that the consent that you have obtained a signature for is from the correct person.
And with that being said, the services that we provide in our outpatient department are individual therapy services. Our outpatient department does not provide group. So for instance, when a therapist or a case manager, let's say, is going into a school and maybe they have multiple clients in that school as students, is it permissible to provide group therapy sessions to all of those clients?
At Chrysalis Health, we only do group therapy in our psychosocial rehabilitation program. Other than that, in outpatient programs, we do not do group therapy.
For instance, going into the school, if you have, for instance, 4 clients that you service that are all Chrysalis Health clients, you have to see each client individually for that individual therapy session, and the service provision is documented in your progress note separately for each individual session. That does not mean that you can take all 4 of those clients, have a group session, and then provide the progress note for each hour for that particular client. So Eddie, in regards to other types of HIPAA violations, what are some examples that you can provide that may seem benign at the time that an employee is partaking in that situation, but in actuality is quite illegal?
There are many things that can happen with regards to HIPAA that can result in an actual violation. You know it when you see it. First and foremost is anyone who's not authorized to view or obtain that information. If it's disclosed to them, it results in a HIPAA violation. It could be as simple as taking a photograph with information that can be seen in the foreground or the background, leaving your laptop in a vehicle or another place where the laptop is stolen. Now, we take measures to secure the information that's contained in the laptop, but nonetheless, it can be a violation of HIPAA if that laptop is stolen and someone is able to obtain the information out of there. disposing of notes or other records that have information that are not shredded or otherwise disposed of properly. You can't simply toss the information into a garbage can and expect that it's protected. Use your best judgment in these cases with regards to what information can be disclosed to someone who's not authorized to have it and the way you treat such information.
Going back to the laptop in a vehicle, what would be a consequence of someone saying, you know what, I'm going to the grocery store, I'm just running in for 10 minutes, I'm going to put my laptop in the trunk of my car, they come out, the laptop is stolen?
We emphasize this because it happens. It happens far too frequently. Laptops that are in view of someone passing by your car are susceptible to being stolen. The information that's contained therein is HIPAA protected information. You must report immediately the theft of any information taken from you or if your laptop is stolen so that we can take the adequate measures to secure that information. Of course, if you fail to follow the protocols of Chrysalis, you're subject to suspension or even termination, and we will ask that you reimburse the company for the loss of the laptop.
In addition to paying back the loss of the laptop, which I believe is $500 for the laptop, you will also be written up as a policy violation. So there will be consequences with that. Second offenses will result in termination of employment.
And the company has to undertake a significant amount of measures to notify the individuals whose information is contained on them. We have to notify them in writing that their information, including social security numbers or other identifying information, may have been lost.
So Eddie, talk to us about professional boundaries in the client's therapist or case manager relationship, and what are some areas that we should be sure not to cross to safeguard ourselves?
Well, there's a lot of boundaries that you should be aware of and should avoid crossing. We've had instances where a personal relationship has developed that's outside the boundary of what's otherwise professional. In instances that I'm aware of, cases where a therapist has rented an apartment to a client or their parent, and that can result in a non-payment of rent, which can result in litigation, which could put the therapist in a very tenuous position with regards to that professional relationship. Of course, any personal social relationships must be avoided. The lending of money must be avoided. Even doing things which you might otherwise think are just being nice or helpful can go too far and cross those boundaries. For example, taking care of a pet while a client is on vacation could have very negative ramifications and can cross those boundaries. Be aware of what the professional boundaries require you to maintain. Assisting clients not just while on vacation or can include when they're in crisis, if they've been Baker acted or and ask you to take care of their home or their pets. You must be aware that this can result in crossing the boundaries of what's otherwise permitted. Use your best judgment. When in doubt, contact your supervisor or contact me, and I will help you guide you through what's appropriate.
There are some other situations, Eddie, where life is very busy and complicated, and some of us have children, some of us may have other situations that come up with a friend or family member, and yet we have sessions scheduled and we want to kind of keep about the day and make sure we follow through with what our clients need. Talk to us a little bit about those types of situations and bringing visitors or family members to a session.
You should not bring anyone with you to one of your client appointments. Even if you're going to the client's home and leaving your friend or relative in the vehicle, you've exposed that person to the address of a client. That in and of itself is a violation of HIPAA. When going to a client appointment, you should go by yourself or with another authorized person who has obtained the same level of consent.
So Eddie, talk to us a little bit also about transporting clients and what the ramifications could be there.
We have a policy against transporting clients unless you're a case manager or it's an emergency situation. There's an important reason for this, is because there are a lot of negative things that can happen during the course of a transportation. Of course, you could be involved in an accident that results in injuries to yourself or the client, and that could have very negative liability for the company. Aside from that, you can expose yourself to being alone with a client in a situation that's not otherwise intended as part of the delivery of our service. In short, do not transport a client unless you're a case manager and it's an emergency.
Eddie, tell us a little bit about what should happen if a case manager or a therapist receives a subpoena regarding one of their clients.
When you receive a subpoena, you should consult with the medical records custodian, who will help guide you through responding to the subpoena. The subpoena could include testimony in court or in deposition, and the production of records, which will be through the medical records department. We will help coordinate the time that you go and attend the trial or the court case so as to fit within your schedule. We'll try to accommodate it as much as possible. Do not ever appear in court or give testimony without being subpoenaed and with consulting with the medical records department. Always remember that your supervisors, officers, and directors of Chrysalis, we're here to help and guide you through your delivery of services at Chrysalis Health. If you ever have any questions, please do not hesitate to ask. Thank you.
And thank you once again for everything that you do for Chrysalis Health. Together we make a team, one mission, one team. Thank you.